Good afternoon. I've decided that the primary reason we seem to have brought John Callaghan and Scott Ritchie here is in order that they could have a chat with one another. So we're going to have to distract them from that fascinating conversation. Welcome to the last afternoon of our program. I'm pleased to introduce as our first speaker John Callaghan, who's a partner at the firm of Smith Lyons. And I know John by reputation, and I know that he's a senior litigation lawyer in the city, but I didn't know and was fascinated to learn that he has actually taken on what I regard as the very dutiful task of being the chairman of the Simplified Rules Committee, which is important and probably something that might not be as uniformly fascinating as some of the things that we all do. But we did hear yesterday something about the simplified rules in the commentary about the few things that might actually be helpful in getting some outcomes without a lot of expense. So it's very fitting that John's going to help us with where things stand today on the simplified rules. And hopefully we'll have time for a couple of questions after John's remarks. So I'll turn it over to John.
Thanks, Wendy. When it comes to the simplified rules, of course, there are two types of people, those that do them and those that never intend to do them. And the simplified rules have been around since '96. We have now concluded our assessment of the simplified rules. They're the first set of rules that were comprehensively reviewed, by which I mean we did a statistical analysis. We met with lawyers and judges to see what they thought of the rule. And what I intended to do today was to tell this group what the results were. The rule is under review at the present time by the Rules Committee, and tell you how this may shake out in the future. The simplified rules were introduced in 1996 after there were considerable reports and concern over the cost of litigation. That concern has been around for years. In the most recent incarnation, it probably started in the Zuber report, followed up with Civil Justice Review. And the concern was that the cost of litigation for the smaller actions was prohibitive. The reports basically pinned the blame on the interlocutory steps between the filing of the claim and the trial, and also the length of time it takes to get to trial, for making costs so prohibitive that either the legally funded or the very rich could go to court and no one else. The background is this. The simplified rules, for those of you who aren't familiar with them, there was a proposal for all cases under $40,000 to have a streamlined procedure which would not provide for discovery, which would provide for a new form of affidavit of documents, and would provide some innovative approaches to trials, such as summary trials, a lower summary judgment threshold. That approach caused a lot of consternation back in '95 and '96. The bar was very concerned that the loss of discovery would result in less knowledge being imparted on the counsel, and therefore less settlements and more trials. They were concerned outside of Toronto that $40,000 was excessive, and there was a concerted effort by Cadelpha, for example, and others to bring that number down or to eliminate the simplified procedure. In the end, the simplified procedures did apply for cases in a monetary jurisdiction under $25,000 and had the sort of hallmark feature of no discovery. Chief Justice Morton, to his credit, decided that for the first time the Rules Committee would insist that the Attorney General pay for the monitoring of the rule to see whether or not it met its objectives. I was appointed along with Madam Justice Sanderson and Madam Justice Wilson to be an evaluation committee to oversee the evaluation. It was a very difficult process because funding wasn't immediate, and it took a great deal of work to get the government to come around. But in the end, we monitored jurisdictions in Kingston, Toronto, and Haileybury on the theory that you had large, medium, and small. As I indicated, that we had a statistical analysis done in those jurisdictions. That was performed by Carl Barr and Bob Hahn. And then we had focus groups, particularly of the lawyers, and there was meetings with the judiciary. There are some interesting facts that came out of the simplified rules analysis. First fact that I found very fascinating was that 25% of all cases in Toronto, and that is basically seen across the province, are simplified cases. That is, they are cases under $25,000. That's a considerable amount of cases in our system that are being prosecuted and defended at the low end. The defense rate is 35%, which is not inconsistent with other cases. The case type, as many of you would expect, a large proportion of the files deal with collection cases. 61% were collection cases on statement of claims, but only 41% of those were actually defended. The interesting statistic on disposition, the disposition doesn't necessarily mean trial. It means the time it comes off the system, which means there's been a settlement or a resolution. On the pre-simplified rules cases, which would be the cases basically in the old district court predominantly, 39% were settled in a year and a half or resolved in a year and a half. After the simplified rules, that number went up to 78%. So the disposition rate, the time it took to resolve these cases, were considerably sped up as a result of the simplified rules. The trial rates was another issue. Everybody was saying no discovery, more trials. That didn't pan out to be the case. Prior to the simplified rules, 14% of all cases between $6,000 and $25,000 went to trial. That actually compares to a number in the general population of cases of 8%. So it meant that smaller cases tended to go to trial at a considerably greater rate than the non-smaller cases, which presumably is because there are a lot of hard feelings in smaller cases. There are less, I would assume, less business people dealing with it, looking at it from an economic perspective, and are driven by emotions. After the simplified rules were introduced, that figure went down to 6%. So it went from 14% to 6%. Now, most lawyers would say that's not a particularly good thing, nothing that we should be crowing about, but it does show that the cases were resolving more expeditiously and more frequently under the new simplified rule. There are other unique features of the simplified rules. The summary judgment test, as many of you may know, was lax, or more lax than it was under Rule 20. Notwithstanding that, I know you heard about summary judgment earlier in the program. Statistics show that in 1998, the number of summary judgment motions were reduced by about half, even under simplified procedure. That's credited largely to the chilling effect the Court of Appeals judgments have been having on Rule 20 and the bringing of Rule 20 motions. There was also a concept of summary trial. If you may remember, you file canned evidence in chief, and then you only get to cross-examine the opponent's witnesses. Summary trial was reached in the present rule by a very convoluted route of filing this, disfiling that, moving across left, go right, that was seen as a real impediment. But the actual concepts of summary trials was well liked. Those that actually did summary trials found them to be expeditious and cost-effective. The big enchilada is the costs. The whole impetus of this was to reduce costs. We first started off with our focus group of lawyers because obviously it's inherently something that you cannot get from a statistics. No one files how much cost was billed to the side. Cost awards inherently unreliable. Very few of these were going to judicial dispositions, so there was hardly anything regarding costs. Lawyers were telling us that they were saving between 30 to 50% from simplified rules cases and non-simplified rules cases in the same vicinity, say $30,000. So there were considerable savings by not going to discovery, not having the motions on refusals, not having the interlocutory fighting that generally accompanies litigation. Because lawyers are inherently unreliable when it comes to dealing with costs and advising on what things cost, we went to an institutional litigant who did not want to be named, but they pulled 40 simplified rules cases that they had. The average settlement was $14,000. The legal cost per case was $2,800. They then did an analysis of their pre-simplified rule settlements under $25,000, which in theory would be in the simplified rules, acknowledging that, of course, you can start a action for as much as you want and settle for under $25,000. But they found that the average legal bill on the pre-simplified cases for settlements under $25,000 was $9,800. So that's a reduction from $9,800 to $2,800. It's a considerable savings if you use that analysis. In the end, it was deemed that the simplified rules had worked. It had achieved its objective. There was a feeling by both the bar, the judiciary, and the evaluation committee that we should increase the amount. After we passed the simplified rules in Ontario, each jurisdiction in Canada passed a simplified procedure. We were, by the end of it, at the low end. $25,000 was the lowest amount. It went up to, I think, $75,000 in Quebec, $50,000 in most of the rest of the country. Admittedly, there's a chart in your material that will show the other provinces, and you'll see that there are different interlocutory proceedings allowed. But in essence, it was decided that the amount should be raised, and it has been proposed that the amount be raised to $50,000. That would result in an additional number of 12.5% of the caseload in the province being simplified rules. That's 37.5% now, which is significant for a couple of reasons. One is that with the the crunch on judicial resources and the movement to case management, more cases will involve less resources. There is significantly less judicial time used in simplified cases. The other thing is it will then allow for a more developed simplified procedure because it'll be more widely utilized. But there were two proposals. The first was to leave it essentially unchanged with some tweaking, which I'll explain in a minute. The second was, and there was a considerable concern, particularly outside Toronto. For those of you outside Toronto, a lot of the people perceive the simplified procedure, a lot of the rules to be a Toronto-centric response to a Toronto-centric problem, otherwise known as Toronto lawyers charge too much. There was, because of that concern, and because of a concern by the negligence bar that you still had to see the whites of a person's eyes, there was a proposal of putting forward modified discovery for cases between $25,000 and $50,000, whereby the discovery would come after a pretrial. There would be an early pretrial, only in cases going to a regular trial, that is non-summary trial cases, and that the parties would be limited to 1.5 hours per party examined. That is, by the deponent being examined, not by the people asking the questions. That there would be a modified relevancy rule akin to Ron Slatt's suggestion in the Advocates Society, which is you answer all questions subject to privilege or it being frivolous and vexatious. There'd be no motions interlocutory. All motions on refusals would be brought to the trial judge with heavy cost sanctions. And the theory being is if you only have an hour and a half, you're going to ask your important questions. In the end of the day, we've been to the Rules Committee once. The Rules Committee actually has preferred the first proposal, and the Evaluation Committee put forward the first proposal as the one that ought to be accepted, which is to leave it essentially the same and go to $50,000. The proposal now out there, in which if you have any concerns, the Rules Committee has considered this once. They will be considering it again in February. If you or an organization which you represent have a concern, you can either write me directly or write Paul Perel over at Weir and Folds, who is the head of the Secretariat of the Rules Committee that actually designs the wording of the rule. But the present proposal would have an increase up to $50,000. You had early pretrials. There would be a pretrial type form exchanging issues because there was a big concern that people didn't understand their case either at the pretrial or, quite frankly, at trial. Judges were complaining that 2-day trials or a day trial was taking 3 or 4 days because the first day and a half was done for discovery purposes. So we're trying to exchange more information beforehand. At the pretrial, you would decide the selection of the mode of trial, which would include either a regular trial, a summary trial, or a disposition by way of summary judgment. In respect to summary trials, which is a very convoluted process under the present rule, would be streamlined. If both parties want a summary trial, you'd get a summary trial. If neither party wanted a summary trial, you wouldn't get a summary trial. And quite surprisingly, the bar accepted this. I had some concerns about it. If one party wants a summary trial and the other one doesn't want a summary trial, then the judicial officer, either the master or the judge at the pretrial, would cast a deciding vote. There would be no case management in the sense that's known in Toronto because these cases are small. Case management costs money, and they don't really need the intervention. Having said that, they're all on a timeline that you'll have to have your a mode of trial or a pretrial within 180 days of filing the statement of defense. So you will be forcing these things along. In respect of mediation, it was recommended that we not have mediation. There are only 6% of cases going to trial. They're obviously resolving. Mediation is anticipated to cost about $1,500 to $3,000 per party by the time you prepare, etc. And it was perceived by most that it wasn't needed. Ottawa has a mediation program. They're going to continue their program. And because of the reluctance to sort of nip mediation completely in the bud, there will be an evaluation of that later. But presently, there will be no mediation, mandatory mediation in simplified cases. That's sort of the framework of what's going to go on forward. I'd be happy to take any questions. I only had 20 minutes. I hope I haven't gone over it. So if anyone has any questions, that's the framework that's going forward.
I just have one question. Under Rule 76, if a plaintiff person action under the regular rules would cease an award of $25,000 or less at trial, there are adverse consequences. Is that rule still going to be in place?
That will still be in place. When that rule, if you look at the rule, it is the typical Rules Committee rule, which is, it isn't shall, it's may, so you have always a little bit of discretion. To be very frank and honest, the negligence bar had a big problem because, of course, often they're starting lawsuits without having the damages solidified, and they were very concerned that they not be penalized.
Do you have any statistics on whether there have been adverse cost awards or cost consequences?
We did not actually keep statistics on that. The difficulty is that there isn't a central repository for that, and it's very difficult through the various court offices. Now, I do have memos dealing with all the various case law, and I suspect there are some. We don't actually have statistics. Sure.
Not really a question, but you made a comment that some lawyers just won't use simplified procedure. We see in our office so many cases that are not simplified procedure, and they all settle for under $25,000. And then that cost consequences, we don't ever come into play, and lawyers just don't want to use the rule. And I just wonder, well, what can you do about it?
Well, I think the problem you're facing is quite considerable because that is exactly what's happening. In outside of Toronto, and particularly in northern Ontario, up Timmins, Haileybury, areas like that, it's purported that they don't really care what we in Toronto say about what simplified rules are or not. They go ahead and have their discovery. And they go ahead and do everything they always did, and they just ignore the rule. Which, if it happens and it works, it works. It's difficult. There's not much you can do unless you want to force it to trial. I mean, you're not going to do that for the purposes of costs, and if you're the defendant, you're writing the check anyway if it settles under $25,000.
I was wondering what you might or might not have done about the award of costs at trial. I just heard anecdotally that a number of judges view a successful claim under the simplified rules that when they go to award party costs, they really lowball the costs because it's simplified rules. So even though your costs might have been $13,000 on a $25,000
Yeah, I'm told, we didn't actually obtain statistics on that, and I'm told that that is happening. In fact, a case that I recently did on a simplified basis, summary trial, I negotiated $15,000 in costs for myself on the other side before the judge had a chance to take a crack at it, because that's exactly what is happening, which is unfortunate because, again, it just leaves that whole net feeling to the winning plaintiff and the same problem. I mean, they just don't get the return that they otherwise ought to. Now, you ought to know this, that the province is going to move pretty clearly to a cost grid system. If you've done any work in Ottawa, you're probably familiar with the cost grid up there where they have partial and substantial cost grids, which no doubt will apply. Partial being this is the most you're going to get if it's on the party and party scale, and substantial being solicitor and client. And right now, and if you do have a voice on this, you ought to get out there and say it. Right now, they're trying to decide whether they're going to regionalize that. The proposal is to use the Ottawa cost base, which has an up to level. For example, a contested motion, it's up to $2,500 a day. Now, there are counsel in Toronto that wouldn't get out of bed for that. So there's going to be a real concern about that cost grid, but your concern in respect to the simplified rules, I gather, is valid, although we didn't have statistics on that. Sure.
Question about simplified procedure claims where I guess there's a movement to have discoveries. I've had two experiences. One was a 5-party action and 4 counsel were pushing for an order that one party be discovered. It was felt that that would go a long way towards settling the matter. And at the pretrial judge made an order that that party be discovered on a very narrow issue. Same situation a few months later, and in that case, the pretrial judge said that he simply had no jurisdiction to make such an order, and we could do discoveries if we wanted to, but he couldn't order it. And then I'm recently told by someone in my firm that there is a master's motion decision saying that there is no right to no ability to get an order for discoveries at all.
I would choose number B. There is no right. There's no jurisdiction. There's no jurisdiction in a judge to order you to go. Everyone should understand there's no jurisdiction under the present rules to order you to have a discovery or be discovered. There is no jurisdiction on a judge to tell you to have a summary trial. You can have a regular trial, call your own witnesses, and do your own thing. There's no jurisdiction. There was confusion. In Ottawa, Master Baudouin had a decision which said that there was a loophole in the rule that allowed you to have interrogatories, written interrogatories. You couldn't have oral discovery, but you could have written interrogatories. That decision was disregarded recently by a Superior Court judge in Toronto, and I think also Master Cork also disregarded it. The intent and the rule was no discovery, written, oral, or otherwise. And if you did do discovery on your own, you're on your own nickel. And in theory, it was felt, although there's never changed the rule, that the court wouldn't allow you to impeach someone on a transcript done on that basis, or read-ins, for example. But we understand that that has happened on occasion. Thank you.
I thank John for that helpful discussion. John wasn't here yesterday when we had our rather bleak review of the recent decisions coming out of the Court of Appeal on summary judgment, which just seemed to get worse and worse. So it's ironic, at least, that through the simplified rules you can still perhaps get summary judgment. It seems you can't get it any other way. I'm pleased to introduce our next speaker, Scott Ritchie. I must say I wasn't aware until we received his CV that his name is Charles Scott Ritchie. You heard yesterday from an eminent litigator in Toronto, Charles Scott, who's sitting in the back row. It is disturbing at the least that there are 2 of them. And I don't think... but we seem to have 2 eminent litigators with at least 2 names in common. Scott may well be known to many of you, practices in London. His firm name is a mystery to me, recently changed to Siskin, the law firm. I confess I had my secretary call his office to check the first time. She put that on a letter that I was being asked to sign because I was sure it was an error, but it's not. It's Siskin, the law firm, no doubt will pay off in some way or another. Scott is also one of our eminent Ontario counsel who have broken ground in the area of class actions on the plaintiff's side, although I happen to know that at least one of his partners has switched sides temporarily. And part of the upside of breaking that ground has been the potential to enjoy the benefits of both contingency fee agreements and the so-called premium for risk that successful plaintiffs' counsel are evidently entitled to in class proceedings. So Scott is going to talk about costs in class proceedings, and we'll be interested to hear what he has to say. We're all interested to know about getting a slice of the sort of $56 million that was awarded to counsel across the country in the blood litigation. I think we'll see if we can get Scott to talk about that in his prepared remarks, but if not, we're going to have questions afterward.
Thanks very much. I'd actually like to start by going back to 1993, because there's been an interesting evolution under the Class Proceedings Act, and I think it's important that we understand that evolution and put it into perspective as far as this risk factor that you were talking about, Wendy. In the first case that was certified, the Bendel breast implant case, we had done a lot of work because this was the first one, and so we put in unbelievable numbers of hours in order to make sure that we were on the right path and that we understood the way in which the U.S. Legislation worked and compared it with ours. And at the end of a 2-day motion, we would have had to have close to $100,000 in that file in terms of fees. Justice Montgomery said, well, this is a procedural statute. No new substantive rights are involved. It was intended to be a straightforward procedure whereby the courts could screen out inappropriate cases. And so after substantial argument, he said, you get $5,000. And you know of Harvey Strasberg's case in Nantes, where we've gone from that kind of model to a model now where party-to-party costs in excess of $100,000 are being awarded on some of these matters. And so, as Wendy said, the risk in these cases is substantial. And I think it's unfortunate in many cases that it's actually increasing, and we're getting further away from the Montgomery model. And I guess to some extent that's inevitable. But I think we should keep in mind where this started. The Law Reform Commission, when it came to the question of cost, and that was back in 1982, they basically, at least the majority of them, recommended a model which was a no-cost model, which is essentially the British Columbia model, and their legislation came into existence after ours, and they looked at ours, and they had some problems with the fact that a representative claimant might have visited upon him or her a very substantial adverse cost consequence when they were coming forward on behalf of a much larger group. And under Section 31(2) of the Class Proceedings Act, everyone in the class, save for that representative claimant, was insulated from the adverse cost consequence. So British Columbia opted for a different model, and I, quite frankly, would have opted for that model as well. But in 1990, the Attorney General's Advisory Committee did another paper on the Class Proceedings Act, and they recommended a different model. They said, let's leave the model that's outlined in Section 131 of the Courts of Justice Act, which essentially leaves the cost issue in the discretion of the trier, with some direction. And so the direction we got was set out in Section 31(1) of the Class Proceedings Act, and it basically says that the judge can take into account three major factors. One Was it a test case? Did it raise a novel point of law, or was it litigation in the public interest? And we have strained since that time to define what a test case is, what a novel point of law is, and what public interest litigation is within the context of the Class Proceedings Act. And what I want to do is to take you through some of the cases and to have you look at some of the factors that the courts are taking into account. But before I do that, let me tell you what I think's happening. The courts, I think properly, are using the cost consequences as a bit of a stick, and in exceptional cases, in cases where the court concludes that the action was commenced without merit, where it was one of those disaster cases from the very beginning. What they're doing is they're simply signaling to us that in those kinds of cases where it might be an irresponsible action or where you may be flying in the face of fairly clear case law, the court's not going to take the Section 131 direction into account if you're unsuccessful. Now, a lot of the cases have developed, the early ones in particular, where a losing plaintiff was asking the court for costs. And the courts have disposed of that argument fairly quickly. And it would only be in an extreme stance where that's going to happen. The real contest is whether or not the successful defendant, who on a summary judgment motion or on a certification motion is successful. And when we're talking about this kind of success, remember the amounts of money that we're talking about at this stage, a far cry from the $5,000 that Montgomery was talking about. We're not, and we're talking about party and party costs. And as we go through this case law, it's clear now that the multiplier effect doesn't come into play in terms of adverse costs awards. It's a party and party award, and there's a little anomaly here that the rules tell us that the courts are not to take into account offers to settle from the defendant. And that rule is not operative within the context of Class Proceedings Act, but offers from the plaintiff can be taken into account. And so with that sort of background, I'm going to take you through a couple of the cases, because it's my thesis that this adverse cost consequence is only used in the clearest of cases. And the courts are going to be guided in the analysis of the cost question by the three major goals of the Class Proceedings Act. And the most important goal, in my respectful submission, is access to justice. And the other is judicial economy, and the other is behavior modification. And I would suggest strongly to you that if you're thinking of starting a class proceeding, you better be able to bring yourself under the rubric of those goals, and you better think about that at the outset, because if you don't, and if your action is dismissed at a fairly early stage on a summary judgment motion or a motion to dismiss because there's no cause of action disclosed in your statement of claim, you could have visited upon you an adverse cost consequence of some substantial amount. Now, the first case I want to talk about is the Robertson and Thompson Corp. Case, which answered the question of when the costs are payable. And this is an important issue. And they said that if there's a favorable result for a plaintiff, the costs should be payable on that party and party scale at the time, because it would be unfair in that setting for the plaintiffs who brought themselves within the goals of the Class Proceeding Act to carry that additional expense through to the end. And let me tell you what gets played out here. This litigation is not for the faint of heart. You're usually involved with large corporations with bankrolls that are sufficient to crush you if you don't have a good case, and if you're not properly bankrolled and you're not prepared to take it through to a conclusion, because the first round is often not necessarily the last round. So that the Robertson case answers an important question of when. And the Mahar and Rogers cable system case, a decision of Mr. Justice Sharp's, as he then was, in 1995, dealt with a motion that was brought on jurisdictional grounds. And the argument quite simply was that the CRTC had exclusive jurisdiction to deal with matters involving cable rates, and Justice Sharp concluded with respect to a summary judgment motion dealing with jurisdiction of the civil courts. He concluded that curial deference had to be paid to the tribunal, and that the tribunal, within the fact context of this case, had the jurisdiction to deal with the matter. Now, the costs were some $55,000, and although this case wasn't started as a class action, there was a motion to convert it into a class action, but that motion was scheduled to be heard after the jurisdictional argument. And in this case, Justice Sharp adopted Winkler J's observations in the Garland case that it had always been open to the court to consider the factors that have been set out in the Class Proceedings Act. And there's a discussion of the public interest litigation. And I want to read to you what Justice Sharp said, because I think it provides guidance to us when we're thinking about these problems. He said, "An unrelenting application of these rules, that is, the ordinary cost rules, will have the result of significantly limiting access to the courts by such litigants. Such consequence would be undesirable with respect to proceedings such as the present one was, in my view, brought on a bona fide basis and which raised a genuine issue of law of significance to the public at large." Now I want you to compare that sort of factual analysis and conclusion with the Edwards versus the Law Society of Upper Canada case, another decision of Mr. Justice Sharp in 1998. And this was a case where the plaintiffs had received funding from the Law Foundation, something I'll talk about in a little more in a moment. But the successful plaintiff in that case sought costs, the unsuccessful plaintiff sought costs on a solicitor-client basis. Justice Sharp concluded that that case was without merit from the get-go, and that the whole question that was raised in this case was fraught with difficulty, and essentially the case was dismissed at the pleadings stage because there was no cause of action that was disclosed. He quickly rejected that claim for the plaintiff's cost and then dealt with the defense costs. And he said, "In my view, the legislature cannot have had in mind that claims so lacking in merit as to be dismissed at the pleading stage would be embraced by the phrase novel point of law." He said public interest, when he spoke of public interest, he said the plight of the plaintiff is plainly not that of a group that has been historically disadvantaged in our society. And he went on and did not award the costs to the plaintiff in that case. Justice Winkler, in the Garland and Consumers case in 1995, where there was a claim for some $112 million of allegedly illegal overcharges by consumers. And in this case, the action was dismissed on a summary judgment motion. The Law Foundation had funded this case, and by that funding insulated the representative claimant from an adverse cost award. In this case, the fund argued, however, that a cost award against the fund, who in those circumstances stood in the place of the representative claimant, would deplete this fund and would thus undermine the purposes for which the fund was set up, and that was to further the three goals that I've talked about. That was rejected and said that's not a factor that the court can take into account. And although Justice Winkler said that Section 131 came into play, and he did not make an award with respect to cost either way, he took out of play the fund's argument that depletion of the fund was a factor that ought to be taken into account. And he basically said that's something that the fund themselves can deal with at the time the application for funding takes place. Interesting side issue in the Garland case. After the main case was over, there was a question with respect to an order being taken out, a straightforward matter, and the plaintiff personally did not cooperate in that happening. And there was a $500 personal award made against the plaintiff for being silly. And that went to the Court of Appeal, and the Court of Appeal affirmed it, and it went to the Supreme Court of Canada, and the Supreme Court of Canada said, no, we're going to reverse that. It was important that the fund purposes be put there, and the fund was to insulate the plaintiff from cost, and if it's going to serve that purpose, we can't deviate from it. So that interesting sidelight was there, and I think that's the first case that we've seen in the Supreme Court of Canada that has come out in this area. Charles Scott, when we talked about preparing this case, sent a case to me and said, Scott, I think you might want to take a look at this case. And Charles and I are engaged in a couple of cases, and I thought there must be a message in this somewhere. Anyway, this is a case out of the Australian courts, and it's the Jonkus and Spruce Falls, it's Jonkus, well, let me get right to the Charles's case. This is Cook and Pasminko, which I put in my paper. In this case, a representative action was begun in one of the courts, and there was a motion brought to strike it because that court lacked the jurisdiction. And so that was a successful motion. The lawyers then went and started the action in another court, and it was felt that by the defendant's counsel that was way out of step with what one might expect by way of normal procedure and reasonableness. And so the motion that was brought for cost wasn't brought against the plaintiff or the representative claimant. It was brought directly against the law firm who took it. And I think, Charles, you were trying to suggest that maybe that door might open here. But what I'm telling you that application is under reserve, and that's a chapter that has yet to be written here in Ontario. There's another case just out recently that sent a bit of a chill among some of the plaintiffs. It's a decision of Justice Cumming in July of 2000. And in this case, employees sought an oppression remedy relating to a corporate reorganization that set criteria for entitlement of the employees to become shareholders. And the claim the claim was that the criteria that had been set out for qualification to become shareholders was somehow unfair to the employees, and so the employees who were not shareholders sought to exert an oppression remedy. And Justice Cumming found that whole argument was without merit at all, and while he said that the criteria might be open to criticism, that wasn't the job of the court to determine that under an oppression remedy. And he reviewed Section 131.1 in terms of novel point of law, public interest litigation, and and notwithstanding that the defendants in this case were Kimberly-Clark and the New York Times, and in a careful analysis, he said that the cost consequences will flow in the ordinary course unless one can engage the three main principles set out under Section 131 of the Act. And he said this isn't public interest litigation. He said it's not a novel point of law. He said the facts might be interesting and novel, but the application to the law was not novel at all. And he said, I cannot see that this is public interest litigation. This is litigation between two private groups, and although there is a group on the one side, it's not something that engages the public interest in the way in which that rule was intended. Costs were awarded to the defendant in that case against the representative claimant, and that's the last case that we have on the point, and it's one that I'm sure defendants are going to embrace. And so when I say to you, if you're going to start a class action, make sure that you review the goals of the Class Proceedings Act, bring yourself within those goals, and look at Section 131(1), because if your action is not reasonably founded, you're going to have to argue that at the end of the day. And you don't want to be thinking about it a year and a half down the line when you've got $500,000 invested in the case and you're looking at a motion for costs, even on a party-and-party scale, that can run well in excess of $100,000. And so the point is, all of these issues must be, in my submission, engaged at the outset before you decide to take one of these cases on. Harvey Strasberg made a talk before a group of judges in London, and I was on the panel at that time, and he said, this kind of litigation is so high risk that he had partners who were not prepared to share that risk, and it resulted in a reorganization of the firm. That's the kind of the risk that is engaged, and my suggestion to you is, if you're going to take a class action on, make sure you've got a case with merit, make sure you've got a case with some equity, and it can be argued at the end of the day that it is in keeping with the Class Proceedings Act goals. Those are my observations on the cost consequences that flow under the Class Proceedings Act as the state of the law exists today.
Not one word about $56 million. So let's have some.
Well, I can tell you about that. The British Columbia Court of Appeal within the last week dismissed the appeal against that $15 million cost award. And so that cost award at this point stands subject to an attempt to seek leave to go higher. And I understand that in Ontario, the case, the appeal is coming forward, I believe, Wendy, in January.
We have some questions for Scott.
In the paper, I did cover off one of the issues dealing with security for costs, and the conclusion reached thus far is that is not something that would fit within the objectives of the Class Proceedings Act, and in particular, access to justice. So that argument has been made and has been rejected. But the important thing to remember with respect to costs, these cases are fact-driven, and the courts are given a very wide discretion under Section 131 of the Courts of Justice Act and Rule 57. And so in an appropriate case, who knows? But the direction that we've received thus far from the courts says security for cost is out.
As a reference, you mentioned the recent case with the Court of Justice coming. Is that cited in the paper? I didn't put the name of the case. Maybe I missed it.
It's not cited in the paper. And let me... That's Jonkus and Spruce Falls Power and Paper Company, and that's a decision that was heard of July the 11th, and judgment was released on the 14th. It has not been reported yet. It'll be in the unreported, yeah.
It's Ontario Judgment number 3228.
Yeah. Thanks, Wendy. John?
A lot of these cases arise from litigation that is perceived, I guess, to be specious. What do you think about the U.S. system, where they have the good faith certification by both the solicitor, the attorney, and the representative plaintiff as to their knowledge of the litigation, the fact, for example, in securities litigation, that they own the shares, they didn't go and buy the shares in order to commence the litigation, that type of thing. New York does that. I think Massachusetts does that.
Yeah, but I think they do that, John, because the class action culture there is substantially different than the experience that we've had to date, and I hope, quite frankly, we don't go down the path of some of that litigation, because there's been a great deal of criticism, and I think this is why in Ontario the recommendation was, and the legislation ended up giving the judges the discretion to weed out the inappropriate cases, because without that tool of an adverse cost consequence, even though it's only going to be utilized in what I would suggest would be the clearest of cases, as long as that tool exists, it acts as a deterrent against silly litigation, and it's a real threat of a tool, as we can see now, given the kinds of stakes, especially in multi-party litigation. Great. Thanks very much.
I never told Scott with the Spruce Falls case that the way it came to my attention was that plaintiff's counsel in one of our cases sent it to me with a note which said, "See, Wendy, they do sometimes not give costs to plaintiffs." So I opened the case to discover that the plaintiffs had lost. And this was being put forward as an example of how the system wasn't all that bad after all. And Scott says today, and I made a note of it, he said that it seems to be settled that the losing plaintiff will only be awarded costs in the rare case. The losing plaintiff. So I say, from the defense perspective, the exposure for the defendant actually getting costs from a plaintiff doesn't seem to be on the radar screen at the moment. I should also notice, someone asked me whether or not there'd be additional copies of Janet Walker's paper from this morning. There should be copies out by the time there's a coffee break, so if you want to pick one up. It's my pleasure to introduce our next speaker, Mr. Justice Robert Blair, who is way over there, but I'm sure I'll be able to persuade him to come over here. As most of you will know, Mr. Justice Blair is the Regional Senior Justice for the Superior Court of Justice, prior to which he has both been a Senior and Distinguished Litigation Counsel in Toronto before joining the bench. And since joining the bench, in addition to taking on recently the responsibility of Senior Regional Justice, Mr. Justice Blair has also taken on some other very significant responsibilities, including a major role in the implementation and running of the commercial court and a major role in the civil justice review. So he comes to us today with an extremely significant background in what is and is not working with respect to the running of our courts. We've given him carte blanche to talk to us about whatever he chooses, and then I'm sure he'll take some questions. Mr. Justice Blair.
Thank you, Wendy. I wasn't sure at all, and still am not. What's really expected of me is, on the topic of views from the Office of the Regional Senior Justice, I must say that when I first read the topic that was assigned to me, I thought it was somewhat a prosaic one, until I looked at the program itself and discovered, in reading the heading of today's subjects, that in fact apparently the views from the Office of the Regional Senior Justice are counted amongst the litigation issues for the year 2000. So perhaps maybe there's more in it than I thought. I don't know. We'll have to wait for the questions, I guess. I'm not quite sure what that says about the fact that the view from the Supreme Court seems to fall into the same category, but we shall see on that too as well, I guess. Fortunately, if I bore you to tears, you have two very dynamic and exciting speakers coming after me, Sheila Block and Mr. Justice Binnie. Sheila and I seem to be on the same circuit this week. Actually, we're both appearing on a panel tomorrow at the Queen's Business Law Symposium in Kingston. The only comfort I can take from that is that I speak after her tomorrow. And as for Mr. Justice Binnie, of course, I follow him in all respects at all times, except for one. A long time ago, I learned never, ever, ever follow Ian Binnie on a speaker's podium, so I'm very happy that I'm not doing that today. Let me start by saying, because I know this is a litigation forum by the Law Society, it's not necessarily a Toronto forum, that I come to you wearing my hat as the Regional Senior Justice for Toronto Region. So my comments are focused somewhat on Toronto Region, but I recognize and have because of my roots, but also because my colleagues, particularly my Chief Justice and members of the bar, keep reminding me that there is indeed another perspective on life than that from the corner of Queen and University. So I say that because I've learned in the last year that the Office of the Regional Senior Justice is in fact a very interesting role to play, but it's sort of equal parts frustration and challenge, and the role is different in each one of the regions. I enjoy immensely working with my colleagues, the other regional senior justices, and we all have different challenges and different problems to deal with. In Toronto, we have a highly concentrated workload, a highly concentrated number of judges. I think we have 93 judges in the Superior Court in Toronto, plus a dozen or so masters. We have a highly concentrated population, and we have in Toronto a very diversified bar, almost as diversified and dispersed as all of you are around this room today. In other areas, like in Ottawa, for instance, they have a very cohesive bar, and that makes things different. In Toronto, we have to cope with a number of multiple courthouses to jump around from one to another. As you know, in Newmarket, that's not the problem. The problem is they don't even have a courthouse up there. So all I'm saying is that we all have different challenges, and we all have different perspectives, and that's part of what makes this province the great province that it is. But it's also why I'm bringing to you today more a Toronto perspective than a province one. Can I just speak for a few moments on where we are then in Toronto and maybe where we're going? Contrary to what some may say, and I'm speaking more on the civil side because this is a civil litigation forum, our caseload in Toronto Region is not down at all. In fact, it's up. It's up about 20%. Over the number of cases initiated in 1999. There seems to be a sense amongst the bar and even amongst some of my colleagues that our workload is down. It just isn't down. In fact, the same is true on the criminal side, which may be even more counterintuitive, because you would have thought that with the introduction of the new hybrid offenses and more cases being dealt with in the Ontario court, that the number of indictments in the Superior Court would decrease. It turns out, somewhat to our surprise, that that hasn't been the case, and the number of indictments has increased this year by about 20% as well. This, of course, has implications for the civil side, because criminal trials receive, rightly so, priority in our system, and as we have to assign judges to hear criminal cases, there are fewer judges to assign to hear the civil cases. The other factor, and I'm sure that you who are counsel are experiencing this as well, the cases that do go to trial seem to be the harder cases and the more complex cases and the longer cases. Having said that, though, I'm pleased to say that I think that we have our trial lists in Toronto pretty well under control. A few years ago, Wendy mentioned the Civil Justice Review. When we started the Civil Justice Review, there was a backlog of somewhere between 10,000 and 12,000 cases in Toronto. Admittedly, some of those cases were soft, but we certainly had a hard core of cases waiting to be tried in Toronto region that were in the high single-digit thousands. Today, there are about 3,800 cases waiting on the trial list, and that's down from 5,500 or so about a year ago. These results have been achieved through the dedication and hard work of many members of the bar who have gone to great lengths to cooperate, to help move cases along, and through the hard work of the members of the judiciary, some from other regions who've come to assist us, and the court's administration people. We are setting more cases down for trial. I think that's the case province-wide. We are trying more cases, and more cases are being settled. And the product of all that effort is that in Toronto, we are now in a position to offer trial dates in, I think, a very timely fashion. What's even more important, and I remember many years ago when I was a counsel, that this was sort of the nirvana that never would be achieved, but we are able to provide more or less fixed dates for trials on the civil side now. You can have a short trial date, less than 5 days, next week if you appear in trial scheduling court and ask for it. You can have a 6 to 10 day trial date within 4 to 6 months, and in fact there are specific dates available earlier than that, as early as next week, as a matter of fact. We can offer long trial dates, that is a trial, we count trials over 11 days as long trials, within 4 to 6 months as well. That's a very significant improvement in the past few months, and in fact we have a few dates available before that too. What we're finding, in fact, is that in many cases we can provide a date for trial before you as counsel are able to accommodate that trial date in your busy schedules. We love that. There are lots of improvements that can be done, but I really do think this is a bit of a success story, and the bar is to be congratulated in part for making this come to pass, as well as, I say, my judicial colleagues and the members of the administration. One of the central factors lying behind this success story, I think, is that we've been able to allocate our judicial resources, for the most part, where they should be allocated. That is, we have the judges trying cases and settling cases. The availability of case management masters and the application of Rule 77 to 25% of our cases has certainly helped enormously in this regard. And so has the application of case management techniques in other areas of the caseload at the pretrials and the trial scheduling courts, for instance. You know, for example, that the equivalent of 3 of our case management masters deal with approximately 10,000 case conferences and motions a year. That's for 25% of the civil cases. So if we had to allocate judges on a 100% basis to those events, 40,000 of them, we wouldn't be able to allocate our judges to hear your trials and to help settle your cases. The fact that we are able to make that allocation, I think, is one of the real reasons why our system is working as well as it is now. The master's office. There have been severe difficulties in the master's office, as all of you, I'm sure, are aware. I'm aware of this, too. And if I hadn't been, that ignorance would quickly have been put to rest by the avalanche of letters that I'm constantly getting from the bar about delays in getting the master's motions on. We don't have enough masters. The case management masters that we have to assign half of them to hear the traditional master's motions, that is, the motions on the non-case managed side, because of attrition. We have fewer and fewer traditional masters. All I can say to you is that Administrative Master McLeod is doing the best he can to deal with this situation given the lack of resources that he presently has to work with, and we are very hopeful that the number of case management masters will be increased shortly. Judges, I might say, are not working to rule on this one, as some press have reported. But the pressures on the Civil Trial Office just don't permit us to allocate more judicial time to the hearing of masters' motions as a general rule for the reasons that I've just outlined to you. Consequently, it's true that judges are encouraged not to hear normal masters' motions in the normal course. It has always been the case, however, and it remains so and always will, that judges will hear masters' motions in urgent situations where the master's office is not able to accommodate such motions within a reasonably required period of time, and Master McLeod has put in place a procedure for assigning dates to urgent masters' motions. I think maybe that's less of a problem now than it was a few months ago. At least I'm hearing fewer complaints about it. It certainly was a problem in the spring and during the summer period. But I think we're getting it under better control at the moment. Maybe since I'm permitted, I hope to muse a bit as part of these views, Wendy, that I could take a moment to reflect upon motions in Toronto. There are a lot of them. There are tons of them, both in terms of numbers and in terms of the materials that are provided. There are, in fact, too many of them, in my view. Toronto region is steeped in a motions culture that seems to be quite foreign to other parts of the province. I can't tell you why that is so. I know that it is. I, of course, practiced in that culture myself for about 20 years. But from my vantage point as the RSJ in the region, I've begun to suspect that maybe we allocate too much of our judicial resources to the hearing of motions. On any given day in Toronto, we may have 8 to 10 judges assigned to hear motions in civil matters, family matters, commercial bankruptcy matters, divisional court matters. 8 to 10 judges. That's half the complement of judges in some of the regions, and in fact, it's about a quarter of the complement of judges that we have sitting on civil cases, civil, family, div court, commercial cases in Toronto in a week. I don't mean to suggest that there aren't many important motions. Certainly there are. And the evolution over the past few years of the motion for summary judgment has helped increase this workload. Some might say that evolution's been a bit stunted recently by some decisions in the Court of Appeal, but there are still a lot of motions for judgment. And also, the increasing resort to applications for dealing with matters has increased the burden on motions court as well, because in those courts we deal with applications to the extent we can without trials of an issue. So there is an increased workload in motions court for external reasons, but there's also a big workload in our motions court because there simply are a lot of unnecessary motions there. Some of them are unnecessary because counsel just don't seem to want to talk to each other and try to work it out. Some of them are there but just because they're not necessary for the case at all, but counsel seems to want to bring them. Someone suggested to me that maybe we should be expanding motions court. Since the trial list delays are now seem to be a little bit more under control, I think you can infer from what I just said that that's unlikely to occur in Toronto region, at least under my watch. Because I think that if it skews the allocation of our resources to do that, and if we do that, we run the risk of undermining the success that we've developed by being able to assign the judges where the judges are better assigned, I think, that is to try your cases and to help you settle them. So I doubt that that's going to happen. There are some things which you as members of the bar can do, though, it seems to me, to help with the motion situation and to help us continue to be able to meet your fixed trial dates. Principal amongst these is the accuracy of your time estimates. Please think about this. Take it seriously. This is really important to make the system work. Accurate time estimates are the foundation of our being able to provide to you fixed date trials and of our being able to make motions court work effectively at all. Some counsel tell the motions office that their motion will only take an hour and 50 minutes so that they get in under the 2-hour limit and don't have to get a special appointment for a long motion. Believe me, I understand the temptation to do that, but it doesn't help. And it doesn't help saying that the motion will take 15 minutes when it's obvious from the 73-page factum that's ultimately filed that you'll be barely able to say hello in 15 minutes on the case, let alone dispose of it. So I urge you to be really careful in the time estimates that you require. Err on the conservative side, if at all. You may succeed in a particular case in getting your matter heard, but if your motion goes 3 hours instead of the hour and a half that's been allocated to it, it means that the motion of your colleague who's waiting behind you, and which could be you the next time around, isn't going to go ahead. And if your 2-week trial becomes a 2-month trial, or your 3-day trial becomes a 9-day trial, then that is it's devastating to the fixed trial system, because all the trials behind you are going to get bumped, and who knows with the permutations and combinations of pulling a trial date together when those trial dates can be resurrected. By the way, the 2-month becoming an 8-month trial and the 2-day, 3-day becoming a 9-day trial are just 2 recent examples of what actually happened. Another thing you can do is talk to your colleagues. Pick up the phone. Talk to them about the case. There's something I like to call the pickup factor. Every time lawyers have to pick up the file and do something significant with it, the chances are that maybe the case will be settled, or at least some part of it will be settled. Set aside the boiling differences between your clients. You are advocates and counselors. You're not mouthpieces for your clients. You have an obligation to advise and to give good advice. And if you do that, the case will move along a lot better too, it seems to me. Now, judges have a bit of a role to play here too, I think. We can and should be more vigilant in enforcing time estimates in motions court. We can and should be more tenacious in pretrial conferences and trial management conferences and walking counsel through the how are you going to prove your case scenario to try to pin down the times as best we can. And I think we're doing that more and more with the cooperation and willingness of counsel, because it works. There will always be unforeseen developments at a trial, but it seems to me that as a general rule, if a trial is estimated to take 10 days, you should be able to finish that trial with a slippage of maybe 20% or 25%. You shouldn't be doubling, tripling the time estimate. I just don't understand how that, I know how it happens, but I don't understand how it happens. One way it can happen is that if your examination in chief is said to take 3 days and it takes 6 days, then the length of cross-examination just goes up exponentially, obviously. So time estimates are really important, I think. The day may come when we'll insist upon time limits for trials. I was interested to hear Lord Wolfe, the Lord Chief Justice, a week or two ago when he was here speaking to the Advocate Society, say that in the UK they enforce time limits. And when I asked him whether that applied to trials as well as appeals and other matters, he said that yes, it does. So it may come here at some time. So where are we going then? Well, in Toronto we're going to go to 100% case management, and we're going to go there, I hope, by July the 1st of next year. This is conditional upon new case management masters being appointed and the proper resourcing of case management, of course. But the Attorney General has told both Chief Justice Lesage and me and others that he's willing to consider the immediate appointment of new case management masters in Toronto. including, I might say, the appointment of the equivalent of one more master to hear construction lien matters. And he also wants to proceed with a number of other civil justice-related reforms, an increase in the simplified rules level to $50,000. That's Mr. Callaghan's baby. An increase in small claims court jurisdiction to $10,000. He would like to see some reform in the discovery area, and there may be a task force set up for that purpose. And he would like to see some changes in the venue rules, or rather the lack of venue rules, and I must tell you the Chief Justice would certainly like to see that as well. So with this package of reforms moving ahead, and particularly with the appointment of new case management masters, we'll be able to move to 100% case management in Toronto. And with that move, we will have the benefit, I believe, of the development of a total case management culture, which is difficult to develop with only 25% of the cases being managed. I hate the word synergy, but there is a certain synergy that's created with 100% case management. Motions are fewer, although overall numbers of attendances may not be fewer, but cases do move through the system faster, and they settle or otherwise are disposed of earlier. That's the experience. There are some new amendments to the present Rule 77, the case management rule, that have been proposed with this transition in mind. These amendments are the product of the combined efforts of the bench and the bar in Toronto, with some input from other areas in the province, under the leadership of a committee chaired by Justice Ground. They are important, these amendments, and they're an important component of the buy-in of the bar, the Advocate Society, and the other organizations in the concept of 100% case management. They feature essentially an early timetabling amendment and the right in an appropriate case to bring a motion for the appointment of an individual judge to case manage the case. There's a great deal of work to be done on this between now and July the 1st if we're to get there by then. There is a steering committee in place. It was established by my predecessor, Regional Senior Justice Lang. It is a large committee, but the bar is very well represented on it by very strong representatives, and it's got a lot to do in the next few months. So how am I doing time-wise? Let me then turn to a couple of other areas with some more musings. I'd like to talk about my philosophy of specialty courts, not specialized courts. When I asked Wendy whether there were any suggestions about areas of interest for the bar that I might touch on, it was suggested that I might comment on specialization. Not to prejudge the issue at all, she asked me specifically whether, given the benefits of specialization, she said, I had any comments on A, using a limited panel of judges for the commercial list, and B, reintroducing a specialized panel of judges for the divisional court. Well, I will comment on these things, but maybe in a more general way. I don't believe in specialization. I don't think complete specialization is a good thing at all, and I don't believe it's consistent or compatible with the role and mandate of a superior trial court. We are a court of general jurisdiction, which means that we are, in essence, a generalist court. People who accept an appointment to our court know that, or should know it, and indeed it's the prospect of such a variety of work that attracts many of us to the Superior Court in the first place. You may think this is a bit of an odd stance coming from a judge who may be a little more well known for his work in the commercial area than, say, for his field in the family law area or the criminal area, but I don't agree with total specialization. Notwithstanding that, I do believe that the court and the bar and the public are best served if we assign our judges for significant terms in areas where they have a particular expertise, interest, and inclination. I call this a specialty approach as opposed to a specialized approach. Keep in mind that even with the development of the UFC, Unified Family Court, the concept is not that the judges who are appointed specifically to that court will spend every day of their judicial career hearing family matters. The concept very much is that even those judges will come out of family for a period of time, from time to time, and hear other matters, and indeed that other judges will go into family on the same basis and for the same reason. So, in the specialty approach, we strive to have experienced judges sitting in all areas of the court at all time, together with other judges of perhaps less experience. Criminal long trials in Toronto is an example of this. In addition, because judges are assigned to teams in Toronto region, we have created, as most of you know, a family law team and a commercial bankruptcy team. Divisional court is also a special assignment, but one of the things that I have learned as a regional senior justice is that there's more to the makeup of the divisional court than what might seem to be to the RSJ's eyes. The divisional court is not something over which the regional senior justice, any of us, has total say in terms of staffing and scheduling. We assign the judges in each of our regions who are going to hear divisional court matters for a period of time, but the scheduling is established by others, and the scheduling of the panels themselves and the overall complement of the panels have to factor in the presence of out-of-town judges on Toronto sittings of the divisional court and of Toronto judges circuiting to other regions to sit on divisional court panels in those other regions. So I'm not sure, really, that it was ever accurate to say that there was a specialized panel of judges for the divisional court. Some may look back on what they may feel as the good old days of the High Court and recall the frequent presence of judges like Justice Robert Reed. But what there was, in fact, was a relatively smaller number of judges on a relatively smaller court, 45, 50 judges, I think, on the High Court, appearing more frequently on the divisional court. No one was there all the time, even Bob Reed. Some were there more regularly than others, and there was always a variety of other judges flanking the regulars. And you know what? It's the same today. Justices Hart, Southey, O'Leary, O'Driscoll, Archie Campbell, J., Justice McFarlane, to a lesser extent, Justices Thin and Lane have been regularly assigned to the divisional court over the past few years. This is to ensure an experienced president on each panel, and to the extent it can be done, experience at the second position as well. There are a lot of faces, to be sure, that council may not have seen before, but I'd just like to say maybe three things about that. First thing is, it's the inevitable consequence of a very large court. The Superior Court has about 270 judges on it in Ontario, and a court with a very large turnover in its personnel in the last 10 years. Second thing is, it doesn't follow that just because you may not have appeared before that judge before that the judge is no good. Quite possibly the judge may be not a bad judge at all. You just haven't had the opportunity to appear before him or her. And it doesn't mean that he or she doesn't know what she's doing, and it doesn't mean that he or she's not familiar with the principles that apply to judicial review and appeals before the divisional court. And the third thing I want to say is that our commitment is to provide a core of experienced judges on the divisional court, while at the same time bringing new blood onto the court so that we will have that continuum of experience to provide when we lose, as we inevitably will, the Justice Harts and the Justice Southeys and so forth, and all of their wisdom and experience. I think that similar comments can be made with respect to the commercial list. See Mr. Scott sitting at the back there looking somewhat skeptical, but I think that it's true. We assign 5 or 6 judges to the commercial list at any given time, and my commitment is that at least 2 of those judges will be wizened old experts, like Justice Farley or Justice Spence or maybe even myself. I don't know. I'm wizened, but not an expert. 1 or 2 of them will be judges with moderate experience, and 1 or 2 of them, depending on the makeup here, and whether there are 5 or 6, will be rookies, newcomers, new blood. In my view, this represents a proper balance between expertise, experience, the benefits of new perspectives being brought to an area in the court, and the need to provide new experience to new judges. Otherwise, as I say, you can't ensure the continuum of experience in the long run. The trouble with total specialization is that judges can become jaded and tired. They begin to think that they know more about the cases that are coming before them than the lawyers do. And you know what? We don't know more about the cases. I hate to admit it, but we don't know more about the cases that are coming before us than you do. You know about the cases. You put them together. You spend hours and hours and hours and hours preparing and being with your client. We just see the tip of the iceberg. But when you sit in one area all the time, you start to think you know a little bit more about the case before you really heard it, or at least there's a serious risk of that being the case. And there's also a risk in a small specialized area of developing closeness between the judges who hear cases in that area and the relatively smaller number of members of the bar who appear before those judges. And that's not necessarily a good thing for either the reality or the appearance of independence and even-handed treatment of cases, in my view. So, as I say, I believe firmly that judges should sit in all areas of the court, although they may spend the majority of their time in their specialty area. But everyone needs to come out of that area from time to time. It reinvigorates them, it provides a fresh face and a new perspective in other areas, and sometimes important developments in the law occur as well, because the new judge has to think about things that others may let slide by from reasons of familiarity and so forth. I don't think it necessarily leads at all to weaker and uninformed decisions, although it may be that in a particular case, at a particular time, the decision takes a little longer to be reached, but frankly, I don't think that's all bad. It's easy to argue in a given case that expediency and an expert approach is the best thing. In the long term, though, it seems to me that total specialization sacrifices the long-term strength and vitality of the bench on the altar of short-term expediency. And unlike Martha Stewart on these things, I'm not sure that's a good thing. I was going to say something about civility. Do you want me to stop now? And you weren't terribly excited, I don't think, Wendy, when I asked you about whether I should say something on that topic, but can I?
We welcome your.
All right, let me just then. Civility and professionalism is a hot topic currently, as you all know, and I don't have time to talk at great length about it today, but I just want to say that I think this is a very important issue, and I both commend and I wholeheartedly support the recent initiatives of the Law Society under the leadership of the Treasurer Bob Armstrong and the Advocate Society under the President Ron Slatt in this respect. 2 weeks ago, as many of you will know, the Advocate Society sponsored a policy forum called Civility in the Legal Profession, and as I understand it from Mr. Slatt, the Society isn't going to stop there. It proposes further steps to promote a fuller awareness of the issues. It wants to focus on meetings with the various constituencies in the profession, the Law Society, the law schools, the judiciary, the senior and junior members of the bar. I don't know what happened to the intermediate members there. Its ultimate goal is the production of a best practices manual, as I understand it, for barristers, leading to concrete and specific educational programs based on those best practices. And this time I am with Martha Stewart. This is a good thing, I believe. You may be interested to know that one of the central topics at the annual conference of the Toronto Region Judges last September at the Briars was a program entitled Professionalism in the Courtroom, the Judge's Role. We talked about a host of matters touching on this subject, including our duties to the lawyers and the public and each other, the relationship between judge and counsel, the obligations of counsel as officers of the court, and the relationship and obligations as between the lawyers themselves and their clients. We talked about comportment and respect in the courtroom, about the impact of the increasing number of unrepresented litigants on these obligations of both counsel and the judiciary. I mention this not only to indicate that judges too are concerned about the questions of civility and professionalism, but also because one of the themes emerging from the Advocate Society's forum, it seems, was that judges need to be firmer and more resolute in the way we control the proceedings before us, and quicker to admonish counsel who step outside the bounds of appropriate professional conduct in the courtroom. And there was a considerable amount of press to that effect. Perhaps we must. Maybe we should. But I would like to think that counsel have some obligations in this regard too. Judges, I know lawyers are as well, but judges are very vulnerable to attack these days for their own actual or perceived malcomportment. There isn't a doubt in my mind that exercising control in the courtroom the way some of my former colleagues exercised control back in the dark ages when I was at the bar would land us immediately before the Canadian Judicial Council these days, and rightly so. The problem is that a lot less than that probably would land us before the Canadian Judicial Council these days as well. And while this chilling effect may not be an excuse for our judges today not maintaining the decorum and fair procedure of their courtroom, the reality is that the line between intervention and non-intervention is not easy to draw, so the fewer occasions on which we're called upon to draw it, the better. I think it may be so that judges need to rethink their willingness to draw that line, but you as counsel can minimize the occasions where it's necessary by observing the simple rules of courtesy, candor, and respect for the proceedings, which have always been the hallmarks of qualified advocates. I hasten to say, by the way, that in my opinion, and in the opinion of most of my colleagues with whom I talk about this, that the quality of advocates in our courts today is generally quite good. Nonetheless, less bickering directly between counsel would help diffuse things, less finger pointing, less impugning of the integrity of opposing counsel, thus engendering an equally indignant reaction on the other side, something that seems to be more and more common in the courtroom. Less of that would help. Less body language signaling counsel's approval or disapproval of a particular piece of evidence or comment or submission would also help. All of these things would be helpful. On a non-courtroom point, so would fewer letters to the judge unilaterally and without the knowledge or even the copying of opposing counsel. I do wish the bar would simply stop this exercise. It's not appropriate. So in any event, as I say, maybe along with the bar, we need to think a little more about our role in the courtroom and our responsibility for maintaining civility and decorum during the processes before us. In an article called Advancing Professionalism Needs Judicial Help, Jerome Shestak, who is the former president of the American Bar Association, began with this following note. Lawyers learn quickly, he said, when judges mean what they say about observing standards. A few sharp raps on the knuckles, and knuckles won't be used as much. So let's try and work together, I say, to minimize the need for those kinds of tactics on the part of the judiciary, and I thank you for this invitation.
We have time for one or two questions if anyone has one. The gentleman in the back row.
Well, I haven't. This on?
Yeah.
I haven't heard of any decision having been made in that regard. I suspect that no steps will be taken to bring the Unified Family Court to Toronto or anywhere else until the kinks are worked out of the growing pains are worked out of the system where it's now newly in place. But after that, I suspect that it will. It's up to
Anybody
the
else?
attorney. He has to decide whether he wants UFC in Toronto or not.
Anybody else? No? Thank you very much, Mr. Sheriff. We're going to take our coffee break now. We're starting back at 3:30 sharp, okay? Not 3:35, just so you know.